Usually when you buy a house, there is this expectation of absolute finality, like it feels like physics.
Right, yeah, it feels totally binary, like you either own it or you don't. You cross that threshold from renter to owner, and society just recognizes that shift.
Exactly. It's clean. You sit in that stuffy title office and you sign that towering stack of paperwork until your hand literally cramps, right? And then the realtor hands you a shiny brass key and everyone smiles and says, congratulations, it's all yours.
And you walk out to your car, and it feels like a rock-solid fact. You look at the dirt in your front yard and think, I am the master of this specific patch of the earth.
Yeah. It's incredibly comforting to think that way because as humans, we desperately like our property and our laws and our rights to be just, well, clearly defined, visible,
Yeah.
permanently categorized. We want the lines on the map to actually mean something absolute.
Oh, absolutely. But then, you step into the world of historical property law and constitutional theory and the origins of jurisprudence, and suddenly that solid ground you're standing on turns into a marshland.
It really does. You realize that what you hold in your hand might not be the absolute bedrock you thought it was, and that is exactly what we are getting into today for this deep dive.
Yeah, we're looking at a legal and historical landscape today that is, well, honestly, it's murky. It's a total labyrinth of forgotten definitions and ancient battles.
It is the absolute definition of diagnostic muddy waters. Because the deeper you look at what the word ownership actually means, in a historical and legal context, the more the illusion of that simple, clean real estate transaction begins to dissolve.
Right, you start pulling on one thread about, say, property taxes, and suddenly you are unraveling the Norman Conquest.
And that is exactly where we are going today. Welcome to the deep dive. Our mission today is to examine a stack of very specific, highly detailed documents, study guides, and legal seminars that we've gathered for you.
Yeah, these materials present an alternative, highly historical lens on American law, property ownership, and really the very concept of individual sovereignty.
We are going to look at how these sources connect ancient history to the modern courtroom. But before we go any further, we should be very clear right up front about the nature of the material we are unpacking today.
Yes, a massive disclaimer is required here just to set the stage.
Right. We need to explicitly state for you listening that some of these sources contain highly politically charged theories. They touch on the absolute limits of government authority, the legitimacy of the Federal Reserve, the validity of property taxes, and concepts that are widely associated by the mainstream with the sovereign citizen movement.
And we are not here to take a side.
Exactly. We are not endorsing these views, and we are not here to aggressively debunk them either. Our goal today is to impartially unpack the fascinating legal and historical arguments exactly as the original authors present them.
We are putting on our explorer hats, stepping into this specific worldview, and mapping out this legal theory just to see how the authors connect the dots.
It's an exercise in understanding a very particular, fiercely independent legal philosophy.
And whether the mainstream legal consensus agrees with this framework or not, and to be clear, sitting judges and bar associations fiercely do not, the historical breadcrumb trail these texts lay out is objectively fascinating.
It really forces you to look at the law not as a static rule book, but as a living, breathing artifact of ancient wars. It really is an incredible narrative arc.
It's epic. Over the course of this deep dive, we're going to trace how a collision of three ancient legal philosophies led to a standoff in a medieval meta.
Yeah, and we are going to explore how that specific standoff forged the U.S. Constitution's Seventh Amendment and how it allegedly created a secret, forgotten weapon of absolute property ownership called the land patent.
A weapon that the authors of these documents claim is still fully operational today, if you know how to wield it.
But to understand any of these modern claims about your house or your mortgage or courtroom dynamics, we have to travel way back in time, don't we?
Yeah, we cannot start in the 21st century.
Wow.
We have to go back to an era when the idea of law wasn't a bound book in a quiet library. It was a literal battlefield between three completely different invading cultures colliding on the island of Great Britain.
Okay, let's dive into that collision. Because we usually think of the American legal framework as a monolith, right? Like it was just handed down on immaculate stone tablets by the founding fathers in Philadelphia.
Right, like it was perfectly formed from day one.
Exactly. But this legal framework argues that it's actually a really messy, unresolved merger of three distinct historical legal traditions.
That's right. The foundation of this entire theory rests on recognizing these three distinct systems and understanding, well, why they formed the way they did. Let's start with System 1, the English or Northern Common Law. Within this historical lens, this system was brought down into England by the Vikings, the Northmen, and the Germanic tribes. And the defining characteristic of this law is that power derives entirely from the people at the bottom.
The people at the bottom.
Right. The rulers serve the populace, and juries, meaning the community itself, actually elect the leaders and decide the rules. It's a true, radical, bottom-up system.
Now, hold on. Let's think about the geography and the culture of the Northmen for a second.
Yeah.
Because we usually picture the Vikings purely as pillagers with horned helmets, right?
Yeah, the classic pop culture image.
But they are framed here as the bringers of grassroots democracy and the jury system. Why would a culture known for raiding develop a system based on community consensus?
It all comes down to the environment they survived in. When you were living in the harsh, unforgiving climates of Northern Europe or Scandinavia during the Dark Ages, survival requires intense communal cooperation.
Makes sense.
A chieftain couldn't just sit in a palace and dictate reality. He had to physically lead his people through freezing winters, failing crops, and dangerous sea voyages. If the chieftain made a bad call, the whole village starved.
Wow. Okay. So the stakes were immediate and literal.
Exactly. Therefore, the leaders were constantly held accountable by the freemen of the tribe. The law wasn't some divine edict. It was simply the common sense of the community. What was best for the group?
So when disputes arose, they didn't consult a giant library of statutes.
No, they didn't have one. They gathered the freemen together in what was called a thing, which was an early form of a parliament or jury, and the community weighed the facts and decided the outcome right there.
So the common law is born out of necessity. It's the law of the land, shaped by the harsh realities of surviving on the land.
Yes.
The jury system isn't some high-minded philosophical invention. It's a practical survival mechanism where the guys holding the spears get a say in how the tribe operates.
Exactly. The power rests with the people, because the people are the ones doing the surviving. Now contrast that entirely with System 2, which is Roman civil law.
Okay, the Romans.
This system was brought to England much earlier, during the Roman occupation, which lasted roughly from 43 AD to 409 AD. And the authors describe this as a compromise system. It sits somewhere between top-down and bottom-up.
Wait, why is it a compromise? How does it differ from the Viking community circles?
Well, think about the logistics of the Roman Empire. We are talking about a massive, sprawling geopolitical machine stretching from the rain-soaked hills of Hadrian's Wall in Britain all the way to the deserts of Syria.
Right, it's enormous.
You just cannot run an empire of that magnitude based on local grassroots community consensus. It would be chaos. You need uniformity.
You need standard rules.
Exactly. You need standard weights, standard measures, standard taxes, and standard rules of commerce. So the Roman model relies on a legislature like the Senate or the emperor's councils to make sweeping, uniform rules.
And then how do they enforce that over such a huge area?
To enforce those rules across millions of miles, you create intermediate tribunals. You create magistrates, administrators, and a vast bureaucracy that stands as a buffer between the central government and the common people.
Okay, I see. It's a very bureaucratic, structured, middle management kind of vibe.
That's a perfect way to put it.
You have the ultimate authority at the top, the people at the bottom, and this massive layer of administrators in the middle, making sure the forms are filed in triplicate.
Precisely. It is the birthplace of the statute, the code, the written regulation. The law is no longer just what the community thinks is fair today. The law is what is written on the parchment by the legislature, and it's applied uniformly by the magistrates.
Right. It's highly efficient for running an empire, but it removes the power of localized common sense.
Completely. And so we have the Viking common law, which is bottom up.
Yeah.
We have the Roman civil law, which is a bureaucratic compromise.
Mm-hmm.
And then finally, the text introduced System 3, the divine right of kings, which they explicitly attribute to the barbarians.
Yes. And I really have to push back on this on behalf of the listener.
Go for it.
The barbarians brought the divine right of kings. I mean, usually when we hear divine right, we think of absolute monarchs in velvet robes in the 16th century, right? Not barbarian tribesmen. How does this framework connect those dots?
It's a fascinating historical leap. The narrative laid out in these documents is that when conquering tribes like the Visigoths or the Vandals finally sacked Rome, they found themselves in a peculiar situation.
What kind of situation?
They had the military might to conquer the capital, but they were vastly outnumbered by the actual citizens of the empire, and they had absolutely no idea how to run the complex logistics of the Roman state.
Oh, that makes sense. You can sack a city, but you don't know how to run the aqueducts.
Exactly. So they made a pragmatic choice. They kept the existing Roman administrators, the magistrates, and the scribes to run the day-to-day operations for them.
Wow. They essentially outsourced the government back to the people they just conquered.
Right. But this created a massive problem of legitimacy. Why should the sophisticated Roman administrators obey this warlord from the north? The barbarian kings needed a philosophical justification for their absolute rule that couldn't be questioned by Roman logic or Viking community consensus.
Okay, so what did they do?
According to this historical lens, they allied with the church. They instituted a new philosophy. The king is not just a warlord. He is the literal, anointed representative of God on earth.
Ah, I see. So by injecting God into the equation, you completely bypass the need for community approval or legislative debate.
Exactly. By divine right, all law flows strictly from the top down. The king is the source of all justice. The king literally cannot do wrong because he is acting as God's vessel.
So if he breaks the law...
If the king does something that contradicts the existing law, he didn't break the law. His action simply changes the law for that moment. His word bends reality.
Wow. Okay, so if we look through their historical lens, the English legal system is like a corporate merger from hell.
It really is.
You have the Vikings acting as a powerful workers' union, demanding bottom-up rights and local juries with their common law. You have the Romans acting as the entrenched middle management bureaucracy, constantly writing policy manuals, statutes, and codes with civil law.
Yep.
And sitting at the very top, you have the barbarians acting as this untouchable CEO, claiming total, unquestionable authority through divine right.
What's fascinating here is how the authors trace the remnants of these three wildly conflicting systems directly into the modern era.
How do they do that?
Well, they argue that despite the American Republic supposedly being founded on the common law, that Viking legacy of the people's power where the jury is supreme, our modern government practice leans incredibly heavily toward the Roman civil law model.
Oh, for sure. The endless statutes, codes, and bureaucratic administrators. We certainly have no shortage of statutes and middle management bureaucrats today.
Right. And even more ironically, they claim the barbarian divine right system still exists today in plain sight. It hasn't vanished at all. It just changed its wardrobe.
Wait, how so? Where do we see the barbarian warlord today?
Walk into a modern statutory courtroom. The texts suggest that in an equity court, the judge acts as the undisputed god of the court.
Oh, interesting.
Think about it. The judge wears a black robe, which is historically a clerical garment, and sits on a raised dais. When the judge speaks, whatever they say becomes the immediate binding reality of that room.
Like bending reality.
Exactly. If the judge strikes something from the record, it legally never happened. They have absolute immunity from lawsuits for the decisions they make on the bench. Much like a barbarian king, their word is unquestionable law in that specific moment.
That is a staggering way to look at the justice system. So if these three systems, the bottom-up workers' union, the bureaucratic middle management, and the top-down divine CEO, are so incredibly contradictory, how did they ever stabilize in England enough to give us a functioning legal system to export to America?
Well, the short answer is they didn't stabilize easily. And perhaps they never truly did.
Really?
Yeah. The tension between the king claiming he owned absolutely everything by divine right, the administrators trying to codify everything, and the people demanding their inherent common law rights created centuries of violent, bloody friction. And that friction reached an absolute critical boiling point in the year 1215.
Right, which brings us to the concept of land ownership, which is really the beating heart of all these documents. If we are going to understand mortgages and land patents, we have to look at the dirt.
We do.
Before 1215, according to this framework, the King of England owned all property, all of it, exclusively. There was no private property, as you or I understand it today.
It was a system of strict feudalism, which was violently cemented into place by William the Conqueror after the Norman Conquest in 1066.
Right.
When William took England, he didn't just conquer the government. He claimed personal divine ownership of every single blade of grass on the island.
Let's talk about the mechanics of that feudalism. How did a noble actually hold land if he didn't technically own it?
The king allowed his favorite nobles, the barons, to use the land, to profit from it, and to sublet it to peasants. But they absolutely did not own it. They held what was called tenure.
Okay.
They owed the king constant taxes, tributes, and heavy military service in exchange for simply being allowed to occupy the space. The titles they held were explicitly of the crown, meaning they were entirely subordinate to the king's superior allodial title.
So they could just be kicked out.
Oh, easily. If a baron displeased the king or couldn't pay his taxes, or simply died, the king could instantly revoke the tenure and take the land right back.
So there's no generational wealth building there. You are entirely at the whim of the monarch.
Entirely.
Although the sources mention a really fun anomaly here, apparently only one specific area in all of England, the county of Kent, was allowed to retain non-feudal land ownership during this period.
Yes, the county of Kent maintained a system called gavelkind tenure, which was a holdover from the old Saxon common law.
The Viking rules.
Exactly. In Kent, land didn't automatically revert to the lord or go exclusively to the oldest son under the Norman rules of primogeniture. The land could be inherited by all the sons equally, and it couldn't easily be seized by the king for felony convictions.
Don't have to manage that.
Kent managed to negotiate this carve-out by essentially threatening William the Conqueror with a massive localized rebellion that he just didn't have the resources to put down at the time.
That's amazing. It's a tiny little pocket of Viking common law surviving in a sea of Norman feudalism. But for the rest of the country, they were locked in this dictatorial control.
And that dictatorial control bred immense generational animosity. For nearly 2 centuries after William, the nobility chafed under this system. They were constantly under the threat that a capricious monarch could just arbitrarily strip their vast estates and titles away under any pretext.
And then this brings us to King John. Let's set the stage for 1215. King John is essentially bankrupting the country, right?
No, completely.
He has fought a series of disastrous, highly expensive wars in France, and he has lost almost all of them. To fund these failures, he is squeezing the English barons dry with unprecedented taxes and arbitrary fees. He is abusing the justice system, having his sheriffs seize property without trials just to fill the royal treasury.
The pressure cooker is whistling at this point. The divine right of the king is colliding head-on with the barons' desire for the security of their property.
Right.
This culminates in 25 powerful barons banding together, raising a massive rebel army, capturing London, and forcing King John to meet them in a literal swampy meadow called Runnymede.
Yeah.
There, at Sword Point, they force him to sign a treaty limiting his own divine power.
The Magna Carta.
The Great Charter, yes.
I want to spend some serious time analyzing this document because the sources highlight some very specific clauses or articles that sound remarkably familiar to an American ear, but the mechanisms behind them are really fascinating.
They really are.
Let's look at Article 24. It says, "No sheriff, constable, coroners, or other bailiffs of ours shall hold pleas of our crown."
Think about the mechanism there. The king's sheriff is the guy who arrests you. Under the old tyrannical system, the sheriff could arrest you, act as the prosecutor, act as the judge, and seize your property all in one afternoon.
Wow. Total conflict of interest.
Exactly. Article 24 severs that power. It mandates that the executive branch, the police force, cannot simultaneously act as the judicial branch.
It's the birth of the separation of powers. Okay, look at Article 38. "No bailiff for the future shall, upon his own unsupported complaint, put anyone to his law, without credible witnesses brought for this purposes."
Again, stripping away the power of the bureaucrat. A government official cannot simply point a finger at you and initiate a legal proceeding that could cost you your land or your life. They also have independent, credible witnesses. The state's word alone is no longer absolute truth.
And then we get to the big one, the cornerstone. Article 39. "No freeman shall be taken or imprisoned or disseized," which means having your land taken, "or outlawed or banished or anyways destroyed. Nor will we pass upon him, nor will we send upon him, unless by the lawful judgment of his peers or by the law of the land."
This clause is the absolute bedrock of the entire legal philosophy we are discussing today. Let's look at the original Latin phrasing for that last part. Per judicium parium suorum vel per legem terrae. By the judgment of his peers or by the law of the land.
Let's debate that phrase, law of the land, lex terrae, because a modern statutory lawyer might read that and say, well, the law of the land just means whatever statutes the legislature has passed. If the statute says you pay a tax and you don't, the law of the land says we seize your house.
But the authors of these historical texts violently disagree with that interpretation. They argue that in 1215, lex terrae meant one thing and one thing only: the ancient, unwritten common law.
The Viking legacy.
Yes, the customs of the people. It absolutely did not mean the decrees of the king, and it did not mean the civil codes of the Roman administrators. It meant that the ultimate arbiter of justice was a jury of your peers operating under the common sense of the community.
So the sources view the Magna Carta as far more than just a dusty historical peace treaty. They see it as a massive technological leap in law.
Oh, absolutely.
It was the physical document that weaponized the common law against the divine right of kings. By securing these rights, they essentially began the long process of ending the strict feudal system of tenure. It secured the right of inheritance. It meant the king couldn't just arbitrarily take the land back when a baron died.
Right.
But I have to push back a little here on behalf of the listener because history is rarely this romantic. I mean, the 25 barons standing in that meadow at Runnymede weren't exactly fighting for the common man, right?
No, not at all.
They were incredibly wealthy landlords. They were protecting their own vast wealth, their castles and their estates from the king's taxation. It seems like the common peasant in the field just accidentally benefited from what was essentially a billionaire turf war.
You're absolutely right to point that out, and a strict reading of history doesn't dispute that it was driven by the elite landlords protecting their own interests. The word freeman in Article 39 did not apply to the vast majority of the peasant population at the time.
Right.
But the mechanisms the barons put in place to protect themselves, requiring witnesses, preventing sheriffs from acting as judges, and demanding trials by peers, were highly effective legal technologies. And over the centuries, through subsequent legal battles, the definition of freeman expanded. The legal tech eventually trickled down to protect everyone.
It's like the barons invented a legal firewall to protect their own servers, but eventually the whole internet got to use the protocol.
That's exactly it. But it is crucial to understand that the Magna Carta was incredibly fragile at first. The moment the swords were lowered, the king looked for a way out.
Yeah, King John didn't just take this lying down. Didn't he immediately try to get the Pope to annul it?
He did. He wrote to Pope Innocent III, claiming he was forced to sign it under extreme duress, which, to be fair, was entirely true.
Yeah, swords were literally involved.
Right. And the Pope, who was allied with John at the time, issued a papal bull declaring the Magna Carta null and void of all validity forever. And shortly after that, King John died of dysentery, and Pope Innocent III died as well.
So the treaty is annulled by the highest spiritual authority. The king who signed it is dead, and the pope who voided it is dead.
Yep.
The Magna Carta easily could have vanished into the footnotes of history as a failed, temporary rebellion. Just a piece of parchment rotting in a monastic archive.
It could have. And this is where the narrative takes a fascinating turn. It took another 82 years, a massive geopolitical crisis, and a very specific, almost magical trick of the law to make the Magna Carta permanent.
Okay, this is the part of the deep dive that completely blew my mind. The texts jump forward to the year 1297. We have a new king on the throne, King Edward I, and Edward is facing a massive crisis.
Let's analyze the geopolitical pressure on Edward. He is fighting expensive, grueling wars on multiple fronts. He is trying to conquer Wales, he is fighting William Wallace in Scotland, and he is engaged in conflicts in France. Wars require massive amounts of money, which means he needs to tax the nobility heavily.
But the nobility is getting restless. The Magna Carta has been reissued a few times over the decades, but it's losing its teeth, right?
Right.
The king's government officials, the sheriffs, the magistrates, they're just ignoring it. They are reverting back to the Roman civil law system of just seizing property and imposing arbitrary fines to fund Edward's wars.
So the earls and the barons draw a line in the sand. They flatly refuse to pay the taxes or provide the military service for the war in Flanders unless King Edward explicitly recertifies the Magna Carta and forces his bureaucracy to obey it.
And Edward, desperate for funds and facing a potential revolt while his armies are bogged down, caves to the pressure.
He signs a document called the Confirmatio Cartarum, the confirming charter of 1297.
And this document is the linchpin for the entire modern theory we are discussing. I want to read the exact phrasing of this charter because the specific words used create an incredible mechanism.
Please do.
The authors quote this extensively. King Edward orders that his justices, sheriffs, and mayors must allow the Magna Carta to be pleaded before them in judgment in all their points, that is to wit, the Great Charter as the common law.
If we step back and look at the architecture of what just happened, this is the ultimate aha moment for anyone trying to understand this alternative legal theory.
Okay, how so?
The king is directly ordering his vast Roman-style bureaucracy to accept the Magna Carta as the supreme common law. But look closer at the operational mechanism. Look at the word he uses. Shall allow the said charters pleaded before them.
Pleaded before them. He doesn't say the magistrates must automatically apply it to everyone.
Precisely. The Magna Carta only acts as the common law if the sovereign individual explicitly claims it as such. The government officials, the bureaucrats, the modern judges, they cannot and will not force it on you. It is not their job to protect your rights. but they must accept it if you demand it.
It's like a legal vampire rule. Think about vampire lore. A vampire might be incredibly powerful, but it cannot just walk into your house. It literally has to be invited in over the threshold.
Exactly.
The Magna Carta is this incredibly powerful ancient protection, a shield against the state. But it can't just walk into the courtroom on its own. The defendant literally has to invite it in by pleading it. If you don't say the magic words, the bureaucracy just processes you under standard civil codes.
That is the exact mechanism the authors are outlining. Your rights are dormant until you vocalize them.
Let's walk through a hypothetical scenario to make this concrete for the listener.
Mm-hmm.
Let's say you get a traffic ticket today, or you are facing a minor property dispute, and you walk into a standard modern statutory court. You stand before the judge. If you just say not guilty, or you argue about the specific wording of the traffic code, what happens?
According to this framework, by engaging with the statutory code, you have silently acquiesced to the Roman civil law system. The court assumes you are a subject of the bureaucracy. You didn't invite the vampire in.
You didn't plead the common law.
Right. Therefore, the judge, acting as the barbarian magistrate, has total authority to apply the statutes, fine you, and close the case.
But if you possess the historical vocabulary, if you stand up and explicitly plead your rights under the common law, demanding a court of record, you are invoking the Confirmatio Cartarum. You are forcing the bureaucracy to switch tracks from Roman civil law back to Viking common law.
That is the argument. The bureaucracy will process you under the easiest, most profitable system available unless you legally force them to do otherwise.
I have to pause here. This is fascinating history, but come on. Does a royal charter from 1297 actually hold any weight in an American court in the 21st century? It sounds like we are, LRRPing medieval history. The judge is just going to bang the gavel and hold you in contempt.
Well, this raises an incredibly important question, and the authors of these texts have a direct, documented answer. They explain that this isn't just an English history lesson meant for a museum.
Right.
This exact concept of common law, the idea that the people hold the ultimate authority and can demand a system outside the king's statutory rules, was directly smuggled across the Atlantic and injected into the foundational documents of the United States.
You're talking about the Bill of Rights?
Specifically, the 7th Amendment of the U.S. Constitution. The Founding Fathers, men like Thomas Jefferson and John Adams, were obsessive students of English legal history. They read Sir Edward Coke and William Blackstone. They knew about the Magna Carta and the Confirmatio Cartarum. They deeply understood the tension between the bureaucrats and the people.
So they built the vampire rule into the Constitution. Let's look at the actual text of the 7th Amendment. Because these sources argue that the power of the people, the legacy of those Viking ideals of bottom-up community consensus, is permanently enshrined right there.
Read the text carefully.
Okay, I have it here. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved.
Let's pause right there. In suits at common law. It explicitly recognizes the existence of the common law as a distinct arena, and it preserves the right to a jury.
And $20 back then was a significant amount of money, but today it means practically any civil dispute qualifies. But here is the kicker, the second half of the amendment. And no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law.
That phrasing is a legal earthquake if interpreted the way these sources do.
Break down the immense theoretical power this grants to the average citizen sitting in a jury box.
Let's look at the mechanics of the phrase. No fact tried by a jury shall be otherwise re-examined. According to the authors, this amendment means that if you are operating under common law and a jury of your peers decides a fact, say, they decide that you do not owe a specific tax or that a bank does not have the right to foreclose on your house, not even the United States Supreme Court can second-guess that factual decision.
Wait, hold on. Are they suggesting that if a local jury of 12 random people decides in my favor, an appellate judge with 30 years of experience literally cannot overturn the decision on a factual basis? That would completely castrate the power of the federal judiciary?
That is exactly the power the framework claims the founders intended. The text defines statutory law, all the codes, regulations, and endless statutes written by legislatures as the law of special interests. It's written by politicians, influenced by lobbyists, and enforced by bureaucrats. It's the Roman system. But they define common law as the general opinion of the people. By guaranteeing that a jury's finding of fact cannot be overturned except by common law rules, which basically just means you can only overturn it by holding a completely new trial with a new jury, The Constitution supposedly stripped ultimate final authority away from the bureaucrats and the judges and handed it directly to a random dozen citizens.
It's the ultimate anti-bureaucracy weapon. The sources claim that bureaucrats and judges find this jury power extremely painful.
Of course they would. It removes their ultimate authority. If a judge cannot overturn a jury, the judge is no longer the barbarian king of the courtroom. The authors argue that while the American system inevitably combined the three original types of law, common, civil, and divine right, the Constitution intentionally biased the system heavily toward the people. The people, acting as a jury, are designed to be the final arbiters of reality.
But let me push back on the danger of this. If the Seventh Amendment gives the jury the ultimate final say, it sounds like the system is designed to allow the community's moral compass to override a rigid top-down rulebook. It's a safety valve against state tyranny. We call this jury nullification, right? When a jury knows someone broke a statute, but they acquit them anyway because the statute itself is unjust.
Yes, jury nullification is the modern term for this specific expression of common law power.
But how does this relate to the physical world? It's one thing to talk about abstract jury trials and ancient English charters in a courtroom, but how does this Viking baron constitutional theory relate to the property we live on, the actual dirt under our feet? Because at the end of the day, people care about their homes.
This is where the deep dive takes a sharp, fascinating turn directly into real estate. The authors connect the ultimate authority of the people over the law directly to the ultimate authority of the people over the land. You have to ask yourself a fundamental historical question. When the American Revolution succeeded and the Treaty of Paris was signed in 1783, King George III relinquished his claim to the American colonies. What happened to his absolute divine ownership of that land?
Well, I would assume it went to the new United States federal government. George Washington and the Congress took over the king's real estate portfolio. They became the new landlords.
Logically, that makes sense. But legally, according to the pivotal Supreme Court case, Chisholm v. Georgia from 1793, a case the sources cite heavily, that's not what happened.
What happened instead?
The court ruled that sovereignty didn't just transfer from one king to a new oligarchy. Sovereignty devolved entirely and directly onto the individual people.
What does that mean, practically?
The court described the citizens as sovereigns without subjects. We didn't create a new king. We splintered the crown into millions of pieces. And because of that, the absolute ownership of the land didn't go to a new federal bureaucracy to hold in feudal tenure. It went directly to the individuals. They became what the sources call sovereign freeholders.
Which brings us to a massive, incredibly important legal term in these documents. Allodial title. Let's define this clearly because it is the holy grail of this entire legal theory.
Allodial title is the absolute ultimate ownership of land. It means the land is not subject to any lord, any superior, or any feudal duties whatsoever. You don't owe rent to the king, and you don't owe military service to a baron.
And in modern terms, the texts explicitly argue that feudal duties include modern property taxes.
Yes, that is the explosive claim.
That is a staggering assertion. They're saying that if you hold true allodial title, the state literally cannot tax your land and a bank cannot foreclose on it because you hold the land completely independent of the state's statutory system. You are the king of your quarter acre.
And how did the Founding Fathers choose to distribute this allodial title to the people? They created a specific legal instrument called the land patent.
A land patent.
According to the sources, a land patent is a direct, unbreakable grant from the sovereign, which was originally the federal government, acting purely as an agent to distribute the land on behalf of the people to a private individual. And the phrasing on these original patents is crucial. It grants the land to the patentee, his heirs, and assigns forever.
Okay, let's stop and look at reality for a second. If I go to my filing cabinet right now, blow the dust off my home ownership folder, and pull out the paperwork for my house, I do not have a land patent signed by the federal government. I have a warranty deed, or maybe a deed of trust.
And this is where the authors draw a massive neon-lit distinction that they claim most Americans are entirely blind to. They claim that warranty deeds, trust deeds, tax deeds, and sheriff's deeds are merely what the law calls color of title.
Color of title. It sounds like a cheap knockoff, something that looks like a title but isn't the real thing.
That is an incredibly accurate way to describe it. The sources use Black's Law Dictionary and various historical court cases to explain the mechanics of color of title. It is an instrument that appears valid on its face. It has the right stamps, it's filed at the county courthouse, it purports to convey ownership.
But it doesn't.
No, it is actually legally defective or inferior. It only conveys a systematic transfer of a piece of property, essentially the right to possess and occupy it, but it does not convey the absolute allodial legal title.
Let's expand on the analogy we used earlier to really make this mechanism clear. Having a warranty deed is like having a really good VIP pass to an exclusive nightclub.
Go on.
It looks incredibly official. It has a shiny hologram on it. You walk up to the bouncer, you show him the pass, and he lets you in. You can sit in the VIP section, you can drink the champagne, you can invite your friends in. To everyone watching, it looks like you own the place.
Right.
But at the end of the day, you don't own the building. The club owner holds the actual deed. And if you break the club's rules or if you refuse to pay the monthly VIP dues, the bouncer can and will physically throw you out into the street.
That's a perfect analogy for how the sources view modern real estate.
But holding a land patent is like holding the actual physical deed to the nightclub building itself. You own the bricks and the dirt. Nobody can kick you out, nobody can set rules for how you act inside, and nobody can charge you mandatory dues.
If we connect this to the bigger picture the sources are drawing, well, they are claiming that the vast majority of Americans do not actually own their homes. Not really. They own a color of title that keeps them trapped in a hidden, modern feudal relationship with banking institutions and the state.
So when I pay my mortgage, I'm not buying the land.
According to this theory, when you get a mortgage, you are pledging the beneficial interest of the property to the bank, while the state essentially holds the ultimate dormant title. You are essentially just renting the land from the county by paying property taxes, much like the barons rented land from King John before 1215.
Wow.
If you stop paying the property tax, your feudal tribute, the county sheriff will eventually arrive to evict you and sell the property at auction. You can't do that to someone who holds true allodial title.
That is incredibly heavy. It reframes the entire American dream of homeownership as an illusion. The authors quote the Supreme Court case Wilcox v. Jackson, which says, "The patent alone passes land from the United States to the grantee, and nothing passes a perfect title to public lands but a patent." They claim a perfected land patent is immune from collateral attack except for outright fraud and is the highest possible evidence of title in the American legal system.
Now, the theory laid out in these documents doesn't just present this as a tragedy, it presents a mechanism for a solution. Yeah, they argue that you, as a modern citizen in the 21st century, can legally act as the assign mentioned in that original 19th century land grant. Remember the phrase, to the patentee, his heirs, and assigns forever.
So how does one actually do that? What is the physical mechanism the sources suggest for claiming this power?
They provide highly detailed step-by-step instructions, which, again, we must stress we're just reviewing for educational purposes, not recommending as legal advice.
Naturally.
The mechanism involves going to the Bureau of Land Management, the BLM, and pulling the original historical land patent for the specific geographical coordinates of your property. These patents were often signed by presidents like Abraham Lincoln or Ulysses S. Grant.
Okay, let's say I have the historical document. Then what?
Then, you have to establish a clear chain of title from the original patentee all the way down to your current warranty deed. You file a complex legal declaration, often called a declaration of assignee, updating the original patent into your own name.
And is that it?
No. You then have to give public notice, which is historically done by publishing the declaration in a local newspaper for several weeks, or filing it in specific county records.
And what does this paperwork theoretically achieve?
The authors claim this process legally extinguishes all residual beneficial interest from lending institutions. It theoretically breaks the feudal chain, elevates your color of title into true allodial title, and legally removes the property from the county's tax rolls forever.
Okay, but let's deal with harsh reality for a second. Let's say I spend months doing this. I follow all the steps perfectly. I pull the original 1850 land patent from the BLM. I file the intricate paperwork to update it in my name as the assign. I walk into the local county tax assessor's office, slap this thick stack of parchment on the counter and say, "Behold, I hold a allodial title descended from Abraham Lincoln. You can no longer tax me. I am a sovereign freeholder."
Right. How do you think the modern statutory system is going to react to that?
I mean, I think the clerk is going to look at me like I have three heads. I think they're going to laugh at me. They will ignore the paperwork, continue to send me tax bills, and then if I stubbornly refuse to pay my taxes based on this theory, they're eventually going to send armed men with badges to seize my house and auction it off. Even if this theory is 100% historically and legally accurate in a theoretical vacuum, does the modern physical legal system actually respect this?
The authors of these sources are acutely, painfully aware of this reality. They do not claim this is a magic bullet that works instantly, They explicitly state that the modern statutory courts, the entrenched Roman civil law bureaucracy we discussed earlier, will fight this tooth and nail.
They kind of have to, right?
They absolutely have to. The county government makes its living on this feudal system of property taxation. The banks make their billions on foreclosures and mortgages based on color of title.
So if the county tax assessor and the local equity judge are guaranteed to reject your land patent, what is the workaround? How do you actually enforce this right if the system refuses to acknowledge it?
According to the sources, the fatal mistake people make is trying to enforce a common law right in a civil law arena. You cannot walk into a standard modern statutory court to defend a land patent.
Because it's the wrong game.
Exactly. If you do, you're voluntarily stepping into a Roman court governed by a barbarian judge who will seamlessly apply civil codes and statutes to destroy your claim. To enforce a land patent, the sources claim you must operate in a very specific, historically pure legal arena, a court of record.
A court of record. This sounds like the final boss level of this entire legal theory. We've talked about the Viking rules and the Magna Carta. Is this where they all come together?
It is the ultimate culmination of the common law. The texts examine the incredibly strict definition of a court of record, as found in Black's Law Dictionary, but they specifically rely on the older 4th edition.
Why the older edition? Why does the edition of the dictionary matter?
The authors suggest the definitions have been strategically watered down or altered in newer post-1960s editions to obscure these common law mechanisms.
Oh, wow.
Yeah, they argue that as the statutory system grew more powerful, it literally changed the dictionary to hide the exits. But looking at the older, purer definitions, a true court of record has 5 distinct, non-negotiable characteristics. 4 are mandatory, 1 is optional.
We need to go through these characteristics in detail, because if this is the only arena where a land patent survives, we need to know exactly what the architecture of this room looks like. Let's break them down mechanically.
Sure. Characteristic number 1. The acts in judicial proceedings are permanently enrolled historically on parchment for a perpetual memory and testimony.
Meaning what? It's not just a passing note jotted down by a clerk.
Exactly. It must be a permanent, unalterable historical monument of the people's will. It is recorded outside of the state's easily editable digital databases. It is a physical testament to a common law decision that cannot be erased by a later bureaucrat.
Got it. Number 2.
It has the power to fine or imprison for contempt.
Okay, so it's not a mock trial. It has real physical teeth. But who exercises this power if it's a common law court?
That becomes clear in the next requirements. Characteristic number 3. It proceeds according to the course of the common law.
Meaning absolutely no statutes, no municipal codes, no legislative rules, and no executive orders apply in this room. Only the ancient common law, only the Viking rules.
Correct. The moment a statute is introduced, it ceases to be a court of record. And now we get to characteristic number 4. The sources emphasize that this is the crucial one, the absolute killer requirement that separates a true common law court from a modern statutory court.
Okay, let's hear.
Characteristic 4. The tribunal, meaning the entity actually making the judgment, is independent of the magistrate.
Okay, let's unpack this word salad. The tribunal is independent of the magistrate. We need to analyze this deeply.
Let's define the roles. In a true court of record, the magistrate, the person sitting in the big chair in the black robe, the person we casually call the judge, is merely an administrator. They are a clerk with a gavel.
A referee.
Yeah, a referee whose only job is to keep order in the room and manage the schedule.
So what can't they do?
The judge cannot make decisions. They cannot pass judgment. They cannot dismiss the case. They cannot rule on the law. The actual tribunal, the entity endowed with the sovereign power to decide the outcome, is either the sovereign plaintiff themselves or a jury of peers.
Let's visualize how a trial actually looks in this setup. If I am the plaintiff and I bring a case in a court of record, the judge just sits there. The judge is not the boss of me. I am the tribunal, or my jury is the tribunal. The jury isn't just deciding if someone ran a red light. The jury is making rulings on the law and the facts.
Exactly. So what does this mean for a modern court? Let's go back to our traffic court hypothetical or a foreclosure hearing.
Well, the sources assert that modern equity courts, the ones you and I would normally walk into every single day, miserably fail these tests.
They do. Modern courts don't keep permanent records in the ancient common law sense. They keep what are called docket sheets or minutes. The authors claim this is a historical hallmark of inferior administrative courts, not sovereign courts.
But more importantly, it fails characteristic number 4. In a modern court, the judge acts as both the magistrate and the tribunal.
Yes. The judge administers the room. Indeed, the judge makes the final decisions based on Roman-style statutes.
Let's return to a sports analogy to really nail this down. In a modern statutory court, the judge is the referee on the field, the commissioner of the league, and the author of the rule book all combined into one person. If they decide you are out of bounds, you are out of bounds. Whatever they say goes.
But in a true court of record, the judge is just the stadium announcer. They just reflect what's happening on the field. They say first down, but they didn't earn the yards. The jury, the people, are the players actually on the field, calling the plays, interpreting the rules, and deciding the final score.
That is a brilliant way to understand the dynamic the sources are describing. And they claim that a land patent, an allodial title, can only be examined or voided by a true court of record at common law. A modern equity court, with a judge acting as a magistrate tribunal hybrid applying civil codes, literally has no jurisdiction to touch a land patent. They are legally blind to it.
This brings us to the immense, almost terrifying responsibility this legal theory places on the individual citizen.
It really does, because if you want to utilize this system, you cannot hire a mainstream attorney to do it for you.
No, you can't. The texts are very clear on this. A standard attorney is a member of the Bar Association. They are literally sworn officers of the modern statutory court. Their loyalty is to the Roman system.
Wow, okay.
If you hire an attorney to represent you, you have instantly surrendered your sovereign status and submitted to the jurisdiction of the statutory court.
You have to do everything yourself. You must have the historical knowledge to recognize your dormant rights. You have to comb through 19th century land records. You have to use the exact formatting and paperwork to demand the vampire rule of the Magna Carta via the Confirmatio Cartarum.
Yes.
And then you must have the immense courage to stand up alone in a hostile modern courtroom, face a judge who has the power to throw you in jail, and declare yourself a sovereign in a court of record, telling the judge to their face that they have no power over you.
The authors of these documents do not sugarcoat this reality. They repeatedly state that this process is absolutely not for the faint of heart. It requires confronting a massive, entrenched system that views you at best as a bureaucratic annoyance and at worst as a dangerous threat to their authority.
The system relies on you quietly acquiescing to its jurisdiction. It relies on you playing by the Roman rules. The moment you challenge it, using these ancient common law tools, the texts warn that the bureaucracy will push back hard, sometimes ruthlessly. They will try to hold you in contempt, they will try to fine you, and they will try to intimidate you into backing down.
It is a breathtaking narrative arc. Let's trace the journey we've taken today. We started with the harsh geography of Northern Europe, where the Viking philosophies of survival forged a bottom-up, people-powered common law. We saw how that system collided with the bureaucratic might of the Roman Empire and the divine claims of barbarian kings.
We watched that tension explode in 1215, with the barons forcing King John's hand at sword point at Runnymede to sign the Magna Carta, securing the right to a jury and the separation of powers. We saw how King Edward I's desperate need for war funds led to the Confirmatio Cartarum, creating a permanent opt-in vampire rule for the common law.
And then we followed that philosophy across the ocean, supposedly injected directly into the DNA of the U.S. Constitution via the Seventh Amendment, protecting the ultimate, unreviewable power of the jury against the state.
Right.
We explored how that sovereignty theoretically extends to the physical earth itself through allodial title and land patents, meant to permanently break the feudal chains of property taxes and bank foreclosures.
And finally, we arrived at the court of record, the hidden, historically pure arena where this common law battle can supposedly be fought and won, provided you have the courage to stand up to the magistrate. It is a totally different paradigm of how the world works. It's a completely alternative operating system for reality.
And it is crucial to reiterate our disclaimer as we wrap up. Mainstream legal consensus, the bar associations, the sitting judges, and the federal government fiercely, aggressively dispute the application of these theories today.
Very fiercely.
They categorize these arguments under the umbrella of sovereign citizen ideology, which modern statutory courts routinely dismiss as frivolous, often penalizing those who attempt to use them.
But regardless of whether a modern judge accepts it, understanding this history, even if it's viewed by the mainstream as a romantic misapplication of ancient texts, gives us a profound appreciation for how our concepts of property rights and courtroom power actually evolved. It didn't just appear out of nowhere, it was forged in conflict.
Exactly. It highlights this eternal, grinding tug of war that has existed for 2 millennia. The tension between the state's desperate desire for efficiency, taxation, and uniformity, and the individual's burning desire for absolute liberty and true ownership.
It forces us to ask deeply uncomfortable questions about the modern world. Do we actually own our land, or are we just renting it under a different name?
Right.
Who really holds the power in a courtroom, the people or the bureaucracy?
It is a lot to process. It completely changes how you look at a simple warranty deed or a traffic ticket.
It really is. And I want to leave you, our listener, with a final provocative thought to mull over as you go about your day. Think about the mechanisms we discussed today. These historical sources claim that your highest rights, true, absolute ownership of your home, and total protection from the arbitrary rules of the state are sitting in a historical vault. And they are just waiting for you to say the exact magic words to unlock them. But if a right only exists when you have the hyper-specific historical vocabulary to demand it, if it requires ancient parchment and archaic declarations to activate, is it really an inherent right, or is it just a forgotten spell? Until our next deep dive, keep questioning the rules of the game.